Hello and welcome everyone. My name is Lynn St. Louis and I am an estate planning and elder law attorney with ELG Estate Planning. Thank you so much for joining me live today and for the Facebook attendees. What we're going to be talking about is what happens if you die without a will, specifically 4 things you should know if you die without a will. So I'm just going to cover those very quickly, and then we are going to get into some of the details. If you have any questions, please post them in the chat or in the comment section of Facebook, and I will be happy to answer them for you today. So 4 things you should know if you die without a will. Number 1 is you do not get to direct where your assets go. It's probably the biggest deal of all. Number 2, everything may end up with the state as opposed to people or charities or where you might want your assets to go. Number 3, you can pretty much guarantee that there will be a probate of your estate upon your death if you die without a will. And number 4, that probate is going to be expensive and complex with litigation fees and a lot of confusion. Contrast that to if you had a will, that you may be able to avoid probate, or if probate is actually something is a good idea for your estate, it won't be complex, it won't be complex or won't be costly. So just kind of sum it up to say, if you die without a will or without an estate plan in place, it's going to be a mess. So let's dive right in and we'll talk about it. And you'll see from the graphics that I'm going to share with you why that is so. I'm going to share my screen. And on my screen here, you should see very tiny letters right now. I will make it bigger. What is a graph to show you intestate succession in Washington state. And what that means when I say intestate is what happens if you don't have a will. So think of what it says, last will and testament, that means you have a will. Intestate means you don't have a will. So if you would let me know, if somebody could just like raise their hand, can you see this okay? Or do I need to make it even bigger? Is that okay? Okay, thank you. So where does this come from? It comes from our laws in Washington state. That's what I'm focusing on right now, no other state. So the RCW 11.04.015 is where this graph comes from: descent and distribution of real and personal property for those people who die intestate. So look at the statute here. That's where all of this graph comes from, aside from one other thing we're going to be talking about at the very end, and that is what happens if there are step parents and how do they avoid what this word is, escheat. What is escheat? That means it goes to the state as opposed to other folks. So let's start with the chart. This chart is actually, it is kind of confusing, I admit it, but hey, if there's not a will in place, it gets confusing. So don't be shy to ask questions. They'll be brought to my attention as well so that we can go over those because I'm happy to answer your questions as we go. So remember, what we're talking about today is what happens if somebody dies and they have not done their estate planning. Typically, that means they have not done a will. Frankly, if there's been no estate planning done, the person doesn't have a will, they don't have a revocable living trust, they've never even thought about where their assets should go when they die. And this often happens with folks who are perhaps younger because the thought of, mortality is not quite so much on their mind. But it happens with everybody. A lot of people just You know, you can avoid doing an estate plan. It's like, can you avoid going to the dentist? Well, for a while, but at some point your tooth is going to get so painful, you're going to get into that dentist. Well, are you going to get in to see the estate planning lawyer? Why? I mean, you might not do so because you know what? If you're going to die, it's going to be way off in the future and you're not even going to worry about it. So, as a result, frankly, it's a large number. It's like over 50% of adults do not have a will, do not have estate planning. And as a result, you are going to see what type of situation their family is going to be left with. So, first question that anybody asks when they're saying, well, what happens to me if I die without a will is, well, are you married or are you single? If you are married, you are going to be under this logic tree. If you are single, you're going to be under this logic tree. So I think let's go ahead and start over here with that you are married, and then we'll come back to what happens if you're single. Okay, so you are married, you're in the state of Washington, and you die without a will. Does your spouse get everything? Notice that's not the first question. The first question that's asked is, do you have living descendants, kids, grandkids? If the answer is no, here's where we go. This one here, let's start here. And I apologize. I'm trying to make this simple as I can with what is kind of a difficult analysis, but you're married and you have kids or grandkids, etc. If you are, your spouse gets 100% of CP. What is that? Community property. SP is separate property. You live in Washington, you're married, you die without a will, your spouse gets all of the community property. Your spouse gets half of your separate property, and your descendants split the other half of your separate property. So we need to stop right here. What is community property and what is separate property? This is going to be a factual inquiry that is done at the court level. Community property, you would think, is everything you and your spouse own, but that's not necessarily true, because what if at the time of your marriage, your spouse came into the marriage, or you did, with what's called separate property? That is property that was acquired before the marriage. If it's property acquired before the marriage, then that's separate property, not community property, and it is going to go half to the surviving spouse, half to the descendants. Separate property isn't just what is acquired before the marriage, it could be what is acquired during the marriage. So if there is an inheritance from parents, for example, an inheritance is considered separate property, not community property, even though you are married. So that property is going to go, it's going to be separate. So it's going to go half to the surviving spouse and half to the kids. This is all going to happen at a probate. This is not going to be handled outside of the court. And commonly there are questions to the nature of the property. Is it community property or is it separate property? So there will need to be a factual analysis, facts brought in, evidence brought in, a court making the decision. If there is disagreement, which likely there will be between the surviving spouse and descendants, because remember, the descendants, or don't remember, I haven't said this yet, the descendants might not necessarily be from the surviving spouse. They can be from a prior marriage. So the relationship might not be an easy, smooth one. So there likely will be lawyers involved, at least 2 lawyers, if not more than that, and there will be a fight or at least an evidentiary hearing based on evidence presented. Is it separate property or is it community property? Which is it? Just as an aside, when we as estate planning and elder law attorneys prepare an estate plan for our clients, we address the issue of what's community and what's separate, so that as if there is going to be a probate, because we want there to be a probate, and even if there's not, there's going to be no disagreement, we're going to have identified what is community and what is separate. That avoids all of that litigation after a death. But getting back to what our circumstances, our scenario is here, this person didn't do a will, so they certainly didn't meet with the lawyer. They didn't do any kind of property status agreement. Okay, good so far? Next in the analysis is the person was married and they died, but they had no living descendants, no kids, no grandkids. So we're here at this part of the decision tree. All right, so if there's no descendants, we have to ask the question, well, were the decedents, the person who died, are their parents living? Let's say the parents are living. In that event, the spouse, again, gets all of the community property. And in this case, they get 75% of the separate property, where the parents will get 25% of the separate property. Parents being the parents of the deceased person. So all what I just talked about with litigation and evidentiary hearing about what's community, what's separate, will come up at the trial on this. If your parents, if the decedent's parents weren't living, so they had no kids, their parents aren't living, then the next step in the analysis is, did the parents have any descendants? That means siblings. Did the deceased person have any siblings? Or if not siblings, would that be then the next level down, which would be nieces and nephews? If the answer is yes, then what happens? Again, spouse gets all the community property, 75% of the separate property, and all of the parents' descendants, that is the deceased person's siblings, or if no siblings, nieces and nephews, divide up the next 25%. Next step is, well, let's say that the parents didn't have any living descendants. In that event, what happens is the spouse gets everything. All of the community property and all of the separate property. So when it comes to married persons, the concern is that there will be a lot of factual questions about what the status of the property is, community and separate. And then it will be a question of, well, who should inherit? The who should inherit isn't as complicated. What's more complicated is the nature of the property. So if you're married, you'll see here that there was no way that the state ended up with any of the property. The spouse may end up getting all of it, or all the community and half the separate property, or 25% of the separate property, and other family members of that deceased spouse share that 25%. Question in the chat is, when a married person dies, does probate commence right away? It depends. It depends on what their estate plan is. So I'm going to stick with our fact pattern here, which there was no will. When there is no will, someone is going to need to affirmatively move ahead and commence a probate. Now, if you're the surviving spouse, are you going to commence the probate? You see, when you commence a probate as the surviving spouse, your spouse had no will, that opens up the door, the opportunity for other family members, be it the parents, descendants, siblings, whoever is going to be likely to be in line to inherit, to argue that, hey, that wasn't community property, that was separate property. So Will the surviving spouse open up a probate? Probably not, because they're going to just take the position that everything is community property and it's all mine. There's no need for a probate. Will other family members, descendants, for example, children from a prior marriage, will they open up a probate? They certainly have a right to do so. They will need to get a lawyer to help them. And if there's merit to their claim that this was separate property, they will end up getting half of the separate property. So nothing is done automatically after somebody dies. There has to be an analysis of, should somebody move forward with a probate? And as you can see in this situation, when the surviving spouse, when the deceased spouse doesn't have a will, they might not open up a probate and do anything. It could be a year, it could be 2 years later that one of the descendants of the deceased person brings a probate. And you can imagine that then at that situation gets even more complicated and more difficult, because you have to kind of do this forensic inquiry as to what's the evidence about the nature of the property. All of this is to tell you that it is a mess if there is a probate without a will and the surviving or the deceased spouse left kids or other family members. All right, we'll get back to this. One of the things about probate or not probate, we all know that people think, oh, probate is a terrible, awful thing to avoid. I'll come back to that, because probate might be a really good idea. But for right now, we're going to move over to the situation when a single person dies and they did not have a will. Okay, so are you married? No. I'll point out here when it says, are you married? Is the deceased person married? No, they weren't married. So then the next question that is going to be asked is, well, were there any kids or grandkids, descendants? I mean, that could go down to kids, grandkids, great-grandkids. Just think of descendants, people who are of the same bloodline, children of various, generations. So, okay, single person dies and they have kids or grandkids or great-grandkids. Then 100% of that estate goes to your descendants. So in that situation, let's say the deceased person had 4 kids and they're all living. Those 4 kids all get 25% of the estate. Let's say that of those 4 kids, 3 are living and 1 is deceased. So for that deceased child, their children step up to inherit that quarter of the estate. So if the deceased kid had 4 kids, they will all get 1/16 of the estate, and the 3 surviving kids all get 1/4, 1/4, 1/4. So it adds up to 100%. Who is a child? Who is a descendant? That is somebody who is either legally adopted or biologically related to the deceased person. It doesn't have to be, it can be the siblings can be half siblings, for example. That doesn't matter. It simply has to be a biological descendant of the deceased person or an adopted child of the deceased person. So what the state of Washington is trying to do here is they are trying to come up with a plan for the person without a will that would reflect what they might want. And if you're a single person and you have kids, presumably you want your kids or grandkids to inherit from you all equally. If you actually wanted to disinherit one of your children, you need a will. If you don't have a will, you are not disinheriting that person. They will inherit an equal share along with your other kids. So one more reason to have a will: if you want to disinherit somebody, you need to have a will to do that. Okay, moving on to this logic tree here. So the deceased person didn't have any living descendants. What's the next step in the analysis? Kind of the same as we did over with a married person. We then say, okay, well, are parents living? If the parents are living, then 100% of the estate goes to the parents. Now, when I say parents, same sort of thing. We are not talking about a step parent. Perhaps, you were raised by someone, your stepdad, and he never adopted you, and you're not his biological. He married your mom, your biological mom, and you considered him to be your father for all intents and purposes. But legally, he's not. And so if you are a single person and you have no kids and you die, your estate is going to go half to your mom, half to your biological dad, even if biological dad had nothing or very little to do with you. Your stepdad is not going to inherit from you. So you were raised by mom and stepdad, and now mom's deceased. Stepdad doesn't get any of your estate. 100% goes to your biological dad. If that's not the result that you want, you will have a will to make sure that that's not what happens when you die. All right, next step. Let's say your parents aren't living, neither one of them. Then do your parents have any living descendants? Again, that's your siblings, or if one of your siblings is deceased, nieces and nephews from that deceased sibling. In that event, 100% of the estate goes to your parents' descendants, your siblings, your nieces and nephews, and then they divide it up. Next step. Okay, well, no, your parents don't have any living descendants. You have no siblings, or if you had siblings, they're deceased and they didn't leave any kids or grandkids of their own. Okay, so then the state is going to look up to say, do you have any grandparents living? And if you do, then your estate goes to your grandparents. If you don't have any living grandparents, then if there are any descendants of your grandparents, here what you're thinking about are cousins. If there are descendants of your grandparents, then your cousins, all of them split your estate. Okay. All right. There's no cousins. There's just no living family relations you have. Then the next question the state is going to ask is, well, do you have stepchildren from a deceased spouse? If the answer is yes, then the next question is, did that late spouse leave pretty much their entire estate to you? And if they did, then on your death, then your stepchildren actually get your estate. In the event that we've answered no, that either you don't have any stepchildren from a deceased spouse, or that late spouse didn't leave their entire estate to you, that your estate comes from elsewhere, then on your death, here is where your assets, your estate, escheats or goes to the state of Washington. So here at this level here, this RCW 11.04.095 was put into place by the legislature to give some sort of a safety valve so that if there was an opportunity for stepchildren to inherit from you, they would. And if these are answered no, that you don't have stepkids or you didn't inherit from your late spouse, the estate basically goes to the state of Washington. Generally speaking, nobody wants their estate to go to the state of Washington, but you can see that is what will happen in the situation where a single person doesn't either have any living family members or stepkids. So That was the state gets all your assets. One of the things that is very clear is that, not this diagram, but what's very clear is that if somebody dies without a will, there is going to be a probate, most likely, because that means there's not any other estate planning done. A probate, I'm sure we've all heard of really a lot of horror stories about probates. This type of situation, dying without a will, is one of those horror stories. So I am going to share with you such a story that is going to show why it's so problematic to die without a will and how costly it really can become. So this is a matter of public record. So I am not sharing with you any private or confidential information. For those of you in the Spokane area, you may remember a jazz musician from decades ago. His name was Billy Tipton. Billy Tipton, upon his death, it was discovered that Billy was a female. And so that was something that was pretty sensational around here many years ago. Well, Billy Tipton was married to Kitty Oakes. Kitty Oakes was, so Kitty is the wife and Billy is the husband. They had 3 children. Kitty Oakes never had any estate planning done, and she lost her capacity, her ability to manage her own affairs, so she became a ward of the state. As an aside, I'll say one of the reasons you want to have an estate plan in place is if you do ever lose the ability to manage your own affairs, your powers of attorney will have appointed somebody you trust to manage things. Kitty didn't have that. So she became a ward of the state with a certified professional guardian appointed to manage her affairs, both financial and personal. What happened next? Well, as you can imagine, she hadn't done a will. So when she died, her estate was probated. She didn't have a will, her estate was probated. She's not married, so you think, okay, well, this should be pretty easy. Didn't I say that she had 3 children? That's what it appeared, that she did have 3 children, three sons, 3 boys. But what we learned through this probate process was that none of those boys was considered to be her legal children. How is that? None of them proved to be biological. We had DNA tests. None of them were legally adopted. They came to the family without going through legal channels. Yet, all of these boys were, by any definition, definitely children of Kitty Oakes and Billy Tipton. From any way you look at it, they raised them. This was a family unit. This went to trial. I was the attorney for the estate. There were attorneys for each of the sons. So there's 4 lawyers involved. And we were litigating questions such as, are you a biological child or not? Are you legally adopted or not? With no one agreeing on anything. So there were a lot of litigation fees in this. And it went to trial in front of the Honorable Michael Price, who is one of our judges here in Spokane, just an outstanding judge and jurist. What he did was he was faced with the decision. What do the laws of intestacy say here? Well, let's assume that these boys weren't legal children. In that situation, what we had to do was we had to look at, okay, who did Kitty leave for her surviving family members? She wasn't married. Kids, we'll get back to the kids, whether or not these kids were actually going to be seen as her legal children. And if not, you had to look up to grandparents. She had none. And then you had to go out and go down to her cousins. And there were cousins in Kentucky. So they were also part of this litigation because we had to give them notice that you may inherit from Kitty's estate. It went to trial. And what Judge Price did was, and this is not a reported decision, by that I mean it wasn't appealed up. Nobody appealed the decision because I think all of us who were involved felt it was the right decision, was that he said, Judge Price did, that there is a doctrine called equitable adoption. And looking at all the circumstances, maybe this wasn't a legal adoption, maybe these weren't biological kids, because they weren't, but for all intents and purposes, the court was going to recognize her 3 sons as being equitably adopted. And by virtue of that doctrine, they were given the standing, the position of legal children. So Judge Price's decision allowed these 3 boys to each inherit 1/3 of Kitty's estate. Personally, I think that that was the right decision. I think that that took a very good judge to reach that decision. But you can see, I think, how easily the estate could have gone to the cousins in Kentucky, because a judge who was not Judge Price might have reached a completely different decision. So in that case, it was the right outcome. It took probably about $100,000 in expert fees and legal fees, et cetera, to get to that point. And her estate was worth about $300,000. So about 1/3 of it went to legal fees, which is proving what I'm trying to tell you is if you don't have a will, you don't know what's going to happen. Other than we know it's going to go to probate, most likely, and there's going to be a lot of legal expenses and a lot of hurt feelings. See, these 3 boys in this case weren't really happy to be in the limelight about their family's situation. She could have just done a will and it would have said to my 3 sons equally and named them. It would have gone there. We never would have known about this case. But she didn't. She didn't do her estate plan. She was under a guardianship. And that was the result, was this case. This case was actually so interesting to the media that the Investigation Discovery Channel did a 1-hour show on it called The Will, Family Secrets Revealed, because it was a sensational fact scenario. I think it's kind of ironic, or at least misleading, that they titled it The Will, Family Secrets Revealed. It should have been, there wasn't a will, Family Secrets Revealed. Had there been a will, we wouldn't have known a lot about what happened. That is probably the most poignant example of what can happen to a family if there's not a will. It was very difficult and devastating for the boys, her sons. Not something I would recommend to anybody to have to go through that. So that's an example of what happens when you don't have a will. And all the complexities that can come into who's heirs at law, I mean, even to the extent of DNA tests. It was kind of an interesting situation. This happened, I think, in about 2008. So it's been many years since then, but you can still probably find that on your, if you were to go Google it and look for The Will, Family Secrets Revealed. Let's see. Other things that I want to point out beyond that, it's really important to get an estate plan in place to avoid a lot of problems, a lot of costs after your death. And I know a lot of reason people don't do it is because they don't have to. There's no sense of urgency to get an estate plan in place, and they don't feel like their estate is that complex, or they're just thinking there's a lot of reasons why not to do it. Oh, plus, the expense of paying, a lawyer to do your estate plan. So maybe people go online and try to do it themselves, which may or may not be better than having a will. It really depends. But one of the things that I want to share with you, see, at ELG Estate Planning, we help people protect assets from all sorts of creditors, state, taxes, long-term care expenses, and none of that will be accomplished if you do your own will or if you don't have a will. So I'm just going to give you an example of why probate actually might be a really good thing for you. Are you married, or do you have a child who either has a disability or lifestyle issues, or are you worried that a divorcing spouse of your child will end up getting whatever your child inherits from you? There's a lot of reasons that you would look at and say, should I protect money for who will be inheriting from me? So I'm just going to give you a spouse situation. It applies the same if you have a disabled child or any other child who you might want to protect. And when I say child, I'm talking about adult child, but if you have a minor child, even more so the reason you need to have a will so that the court would know who to appoint as that child's guardian. So a really simple example here. You're married and you and your spouse together are not particularly worried about much of anything. But you went to an estate planning lawyer who understands asset protection and government benefits, an elder law attorney. So you and your spouse, let's say you have $1 million of assets. $500,000 is what your house is worth. And you've got $500,000 in other investment accounts, IRAs, 401ks, that sort of thing. And you went to a law firm who prepared for you a will that contains an asset protection trust. We do that all the time when we are dealing with our senior clients. But let's say you're 40, let's say you're 50, let's say you don't have any diagnosis of Parkinson's or Alzheimer's or you're not worried about long-term care, even though once you hit 65, most people do worry about long-term care, but you're younger. So you have $1 million of assets, you and your spouse. And in your will, there is a trust that can come into existence if it's needed to protect assets. Sadly, what happens is you and your spouse are in a car accident. And let's say you are killed and your spouse survives, but they have become disabled in some way. They can no longer work. Perhaps they're a paraplegic or something. Something happens to them that everything just went awry. If you have the kind of will that I've been describing, you will want a probate because we can protect 1/2 of the assets. It's a community property estate. You've done a community property status agreement. Deceased spouse dies. Their half of this $1 million estate, or $500,000, is going to go into an asset protection trust for the surviving spouse. So the surviving spouse can no longer work. They need asset protection. We likely will take $500,000, that liquid assets, put it into a trust for the survivor. Surviving spouse has $500,000 in this special trust. $500,000 is their house. If they need the state to pay for their care, which they likely will, they qualify for Medicaid benefits. No spend down required. They are eligible for benefits despite the fact that they own a $500,000 house and they have $500,000 in trust. Why is that? How does that work? It works because as an elder law attorney and an elder law firm, we understand what the government benefit eligibility rules are and how to protect assets. So we basically can protect $500,000 and the surviving spouse is eligible for Medicaid. In order to do that, they had to have the right kind of will, which is what we prepared for them, and they need a probate. This is my example of why a probate might be a very good thing. So probates in Washington are what we call non-intervention, means the court isn't involved with every decision. The court simply signs an order that says this is a good will, and the personal representative or the executor is authorized to act without a bond, without intervention of the court. So they do their job to fund this trust through the probate process. Yes, there are legal fees. There are legal fees that are going to be involved for preparing the estate plan, and there are legal fees that are going to be involved with funding this trust. So that is why people shy away from it, from doing an estate plan, is that there are going to be legal fees. In this situation, though, what I hope to convey to you is we've protected $500,000 of assets, and there is eligibility for the state to pay for that long-term care for the rest of the surviving spouse's life. Yes, that cost money in the estate plan and in the probate, but frankly, legal fees of $5,000 to $10,000 or in that range for those types of services are well worth that outcome. Estate planning, I'm not saying everybody needs a probate. What I'm saying is understand whether probate is the right thing for you. As often as we will set up an estate plan to go through probate to protect assets like I just described, we often will set up an estate to avoid probate so there are no costs upon death. What's right for you, that is really going to be dependent upon your situation, but I do encourage you to seek out a very qualified estate planning and elder law attorney to provide you answers, because everybody's situation is different. So I am pretty much at the end of the presentation here. Couple of questions that are in the chat here. I'll get back to the living will one. If you're in the chat here, just note that we actually have YouTube linked to the Will Family Secrets Revealed. I just said that was done a long time ago, so keep that in mind when you look at it. Yeah, that is me in that one. Do we work with same-sex married couples? Absolutely. All of these opportunities and planning all are available for same-sex couples. All right, getting back to a question that is coming from Facebook. It's a question not about a will, but about a living will. What that is this is really confusing. You may have heard the term living will. That has nothing to do with your last will and testament. Though it sounds like it, doesn't it? A living will is an advance medical directive or a healthcare directive. So that is what I call a living document, whereas a will is a document that takes effect only upon death. Your living will is in effect during your lifetime. And what it says is what your wishes are if you are at end of life in a permanent vegetative or terminal condition. Do you want heroic measures or do you not? If you don't have those documents, like an advance directive, a living will, what's going to happen? What's going to happen is that the doctors are going to turn to your family members to ask questions about what does this person want? Do they want heroic measures or not? Well, who are the doctors going to turn to? You know, it's not that uncommon that people don't have durable powers of attorney for healthcare and a living will. So there is a statutory scheme that says who does the doctor turn to first? First, they turn to a guardian. Okay, if there's no guardian, because there's no guardianship, then they turn to the attorney in fact under a power of attorney. We don't have that either yet. So who is going to be next? Spouse? Okay, let's say there's no spouse. Kids. All right. Who? Oldest kid? They look at all the kids. If there's 4 kids, then 4 children are going to be there trying to agree and make decisions about what should happen to mom. And you can imagine that really creates a bit of a problem and chaos for the healthcare provider. So sometimes the healthcare provider actually petitions for an emergency guardianship. So, and then whoever is in this order, this hierarchy, is going to be trying to convey what your wishes are. So again, just like not having a will, not having your living documents, your powers of attorney, your advance directive, your living will, can cause a lot of problems, a lot of angst, a lot of confusion, and cost a lot of money. All right, next question. I know every situation is different, but what is a ballpark figure on the cost of creating a basic will, advance directive, power of attorney, etc.? So everybody's situation is different. For somebody who has a taxable estate or a very complicated, business interest, etc., I'm not speaking to them. But for people that are just saying, my life isn't complicated, I'm married, I have kids, or I don't have kids, but I don't have an estate that's above 2 million, or my spouse and I don't have an estate over 2 million. What should I expect to be paying? Or I'm a single person. What should I expect to pay? This is what I can tell you. You should expect to pay more than $500. You should expect to pay probably in the lower part of $2,000 to $3,000, up to potentially up to $10,000, $8,000, $9,000, or $10,000. Those are kind of the range that I am going to put out, what you can expect to pay. Let me caution you about a few things. When you go to a lawyer, usually lawyers that do a lot of estate planning like we do will tell you exactly what it's going to cost. We will tell you a flat fee. Why is that? Because we understand what's involved. And of course, there are outliers, to both ends of the spectrum, but a flat fee is what you will want to get a quote on, as opposed to the lawyer telling you that they are going to charge you hourly for the services. Estate planning services, unlike Medicaid applications or probates, estate planning services are typically flat fees. Be cautious of somebody who can't give you a flat fee for estate planning. Also, be cautious of people that say, you know what, I'll do that trust for you for $1,500. Oh, you want the asset protection trust added to it? That's going to be another $750. Oh, you want general durable powers of attorney? We're going to add another $1,500 for those. What I'm saying is be careful of that add-on keeps on going up. So by the end of the day, you are at $10,000. Somebody's going to be charging you that much money. They should tell you that outright so that you can make an informed decision about, is that worth it to me? Is that an investment that I want to make? Or should I go shop around? Just like anything, if you're looking for a service, make sure that you talk to the law firm, you interview, you feel comfortable with them, they have depth, so that if something happens to them, if the lawyer dies, that there's a legal team behind them to support your plan. You may want to go interview more than one law firm. We always encourage people, if you want to go interview law firms, please do so. Come to us at some point, come to us last, come to us whenever, because you're really trying to find out, is that law firm a good fit for you? And does it make sense what they are telling you? And do the costs make sense? And is it put in writing? Here's what the fee is going to be. I apologize. That was a huge, long-winded answer to the fee question, but I appreciate you asking it. Thank you. Will a holographic will be enough? Washington does not recognize holographic wills if you created it here. Let me step back. What is a holographic will? So a holographic will can be somebody who is sitting at a restaurant or a bar in a state where that state will say, you know what, just say who you are, where your assets are going, sign it and date it. That's good enough. That's a holographic will. It does not follow any formalities. I'll get to that. So I can't tell you what states do allow holographic wills, but if you are in a state and you create that holographic will and it was valid in that state, when you move to Washington, we will, under the, I think it's under the Equal Protection Act, full faith and credit, excuse me, we will honor that will. Even though if had you drafted it here in Washington, we wouldn't. But if you draft it in a state that does honor it, bring it to Washington, yes, the court should say that's a valid will. I can tell you that it's going to be a very costly probate because you wouldn't have put in it who the executor is, who your personal representative is, that it should be non-intervention probate, they should serve without bond, on and on and on and on. It's a terrible idea to do a holographic will. It will create all sorts of problems. In Washington State, what do we need to have a valid will? Number one, the person who's drafting the will, the testator, the person who's signing it, they have to have legal capacity. They have to understand what they're doing. They have to understand basically what their estate is, what it's composed of, and who are the people who would typically inherit from them, family members, etc. They have to know what they're doing. Beyond that, they need to sign it in front of two witnesses, and those two witnesses and the person who signs the will, they do it at the same time. And then in addition to that, those two witnesses should sign what's called a self-proving affidavit. That's a document that's part of the will, but the notary, there's going to be a notary, so now we've added another person, will say, I saw these witnesses who attested to the capacity of the testator or testatrix. And that way, if it's a self-proving affidavit attached to this will, when the person dies, the will be admitted to probate, all the formalities are met. Those witnesses don't need to come back into court after the death to say, yes, I saw the testator sign, this is a valid will. Without that affidavit, the witnesses do need to come into court later, and you can imagine years down the road, witnesses might be deceased. So that creates all sorts of problems for a will if we don't have a self-proving affidavit. Anybody who's a witness should not be related to the person who's creating the will. They should not be receiving any assets under the will. So, family members can't witness wills. Those are just some examples of problems when people try to do the wills on their own. Do-it-yourself kits legal in Washington? Yeah, there are. I mean, you can go, you can get kits, or you can sign up for a service. They're typically about $500 or so. Kits can be only $50 or so. And if you follow the directions, the will may be valid if you follow everything that I've described, having independent witnesses and a notary to sign the self-proving affidavit, etc. The pitfalls are, you don't know what you don't know. You fill it out, you follow the forms, but you can bet those forms, those kits were not intended to, avoid loss of an inheritance by somebody who's inheriting from you. There won't be any trusts in it. There won't be any asset protection in it. It's possible that such a kit will be effective and will avoid a lot of these problems. It's just as possible that all these planning opportunities won't be used, because how would you know using a kit? So at the very least, reach out to an estate planning and elder law attorney. A lot of law firms, most law firms, our firm, for example, typically once we've gone through some questions and know that it's potentially a good fit, we'll offer a complimentary consultation. Not always, but it definitely is something that we will do. So really there's no out-of-pocket cost or risk to you just to find out more. But I would recommend that you seek out an estate planning lawyer, elder law attorney as well. Now, We're almost to 1 o'clock. I appreciate your patience. I do want to say one thing, because I've been saying estate planning and elder law like they're the same thing. Let me be clear. An estate planning lawyer can do your estate plan. An estate planning lawyer will make sure on your death, your assets go where you want them to go. An estate planning lawyer definitely can help you with what happens on death. How I distinguish what an elder law attorney is, and I call myself an elder law attorney, is we do that. Plus, we make sure that you are protected from the time you sign your estate plan until you die. That can be a long journey. What happens during that journey? You might lose capacity. You might need long-term care. Your family dynamics might change. There are so many things that can happen during your lifetime. And it's an elder law attorney that can help you with whatever changes during your lifetime. If you go to an estate planning lawyer who doesn't hold themselves out to be an elder law attorney, ask them, what happens now that I've signed these great documents? What happens if I need to go to a long-term care facility, or I need long-term care while I'm alive? Are you going to be there to help me? And if they say, no, I'm not, I'll send you to an elder law attorney because I don't do that, then maybe what you should do is start your journey, start your process with an elder law attorney, somebody who can stay with you all the way throughout your life, help you if you ever do need long-term care, and make sure your estate is handled and administered, depending on your plan, with or without a probate, somebody who's there for you throughout that journey. So thank you everyone for being a part of this discussion today. I really appreciate it. We are going to be sending you, those who signed up, we will send you via email that intestate chart we went over. If you have any questions, feel free to reach out to us here at ELG Estate Planning. Again, my name is Lynn, St. Louis, and our phone number is there in the chat, 509-468-0551. I really appreciate your questions and you being here today, and take care, everybody. Thanks so much.